We are in the last 3 weeks of content. So, whilst there are technically 3 topics to go, they're really just different weeks in one big topic, which is about reading contracts or identifying the terms of a contract and working from there. So, I want to cover off quite a number of things today. I'm going to try and get through as many as I possibly can. I don't think that I've got any desk recordings at this stage for any of this. I might need to add some, depends on how fast we go. But it's kind of a nice section of the course now because we understand the way the contracts work well enough that we can sort of engage a little bit with the stories and think about how they fit together. So I just want to put this in context at the moment. In thinking about the contents of a contract, we break it down into these 3 topics. We look at what the express terms of the contract are. We look at whether there are any gaps and whether the courts or the law generally, or including statute, will imply any terms. And we also need to understand how to construe or read the terms of a contract. All I expect to do today is talk about the express terms and provide some of the context. But again, a lot of this folds back in on itself. A lot of what we're talking about here, we've thought about to a lesser degree when we've thought about the formation elements of the contract, particularly around identifying what an offer is, and more recently when we thought about the certainty. I like this section because, as I've said a number of times, I'm a lover, not a fighter. I like writing contracts and thinking about the way that the deal is going to be put together and to continue. I like the thought of being able to write contracts that my clients can use as a description and a rule book for the deals that they do, but I'm doing that with one eye to how the courts might interpret the contract if they have a dispute, and I guess with the other eye, I'm now sort of some cross-eyed dyslexic person as I think about this image, to thinking about the things that have gone wrong in previous cases that I can learn from. So a number of the cases that we look at now, we look at parties who are unhappy with the terms or the contract that they're in, and what can we learn from that? What can we write into a contract to determine or to avoid those problems? I'm itching to ask you what has happened, Michelle. So, before we get too far in, once again, I just want to take a high-level view. Before we examine this particular section of the jigsaw puzzle, let's stand back again. The way that we have approached this course so far is we started off down the bottom of this arc, thinking about what the elements are, what we needed to have a properly formed contract. And then we've moved through, and in the last couple of weeks, we've discussed a number of elements that can affect that formation, that don't go to whether we have a contract or not, but go to whether or not that contract might be enforceable. And now we're at the stage where we're looking at, assuming we've got a contract, assuming that those kind of factors haven't impacted it, what does it mean? What does the contract itself mean? So we start with, do we have a contract? We ask ourselves, if we do, whether it's an enforceable contract, and then we go to what does it say? Now, the reality is in the real world, you might end up asking those questions in a slightly different order, depending on what the most important issue is for you. So these 3 topics are all aimed at understanding, in fact, what the parties have agreed to. Now, again, we do this objectively. So I'm using shorthand there in a sense by saying they're aimed at understanding what the parties have agreed to. In fact, it's aimed at understanding what a court will say or uphold that the parties have agreed to. based on the words they use, the actions that they said, or the things that they did, the activities that they were involved in. So the kinds of questions we're talking about are, what are the terms? What are the express terms? Where would we find those express terms? What is the legal effect of those terms? If there's something missing, will a court fill that gap in? And ultimately whether a party can avoid responsibility or has obligations under the contract itself. So some of you have already been playing around, I assume, with my kind of cheat sheet. My cheat sheet comes from this kind of map, this massive mind map that means nothing to anybody other than me, but is part of how I pull this stuff together. And I guess I think about it in this way. So the stuff that's in green is what we're looking at in the express terms element. So you can already see just by the quantity that we're probably going to eke into next week a little bit as we talk through some of this stuff. Then we move on to the stuff in topic 10, which is in orange, around the gap filling. So in express terms, we're looking at what are the terms? What have the parties said to each other? What's been written on a notice or a ticket or in the actual document itself? But if there's a gap, then will the courts imply a term? Or is there legislation that requires a particular term regardless of what you write down? And that brings us into week 10. And then we finish by looking at a particular kind of term, really as part of our understanding about how they're read. And we're going to look particularly at excluding or limiting terms. So we have mentioned these kinds of terms a number of times, but these are the terms in contracts that limit somebody's liability or obligations. So a particular type of term. And in that context, we'll think a little bit about how to read a contract. So I want you to think, as we're going through all of this, why it's even important to work out what the terms of a contract are. I mean, let's face it, who hasn't clicked on something saying, I accept the terms without looking at them? I did it today with the government. How scary is that? I thought about it afterwards. But apparently the terms of MyGov have been changed. That's the only basis on which they send me my BAS that I have to complete. So essentially, the irony of this mounts, I've got a text message telling me that there's a message in there. I need to read that message in order to pay tax. And before I can read that message, I have to accept some terms and conditions that I don't read from the government. And I teach contract law. Pretty scary, really. Don't have to think about it all too hard. So why is it important to know what the contract terms are when clearly you don't have to confess, but I'm thinking I'm not alone at occasionally taking on obligations or rights without actually looking at them. Does it matter? It does matter. Can you speak a little louder? I am bound by it. I'm not quite sure what I could be bound by. I'm thinking they've got the, I'm going to have to pay that tax anyway, right? Whether I read the message or not. In a whole heap of different ways. But yeah, that's the source of where my obligations are. That's the source of where my rights are. So, where do we find the terms of a contract? Essentially, the terms of the contract can come from anywhere, really. What do we need to have a contract? We need to have agreement. Agreement comprises offer and acceptance, or if we can't separately identify those things, a meeting of the minds, consensus ad idem. We have established through our exploration so far that silence alone can't be acceptance, but a nod, a wink, in an appropriate circumstance, a shake of the hand can be. We have established that none of the elements of contract, agreement, consideration, intention, certainty. None of those things are writing. Writing is not a formation element. The formalities affect the validity of some contracts, or the enforceability, I should say, of some contracts. Absence of writing doesn't mean that there is no contract. It just means that in certain circumstances a court won't enforce it. But writing doesn't necessarily mean smudgeable ink on paper either. Writing could mean any kind of writing on any kind of platform. Most writing that we read now is in electronic form. There's no particular reason why we couldn't make a contract on Twitter or on Facebook or, as I've suggested there, Tinder or Wickr or Grindr, WhatsApp, Blackboard, for heaven's sake. You could actually make a contract on the discussion boards for this subject. It possibly would be the first interaction that anyone in the first face-to-face class had on the discussion board, but a contract could be formed nonetheless. Contracts can be entirely oral. So the terms can come from what we say, from our activities. Sometimes we've explored the idea of a contract that is entirely by action. Pointing, paying money, ending up with coffee. We can make contracts in a whole range of different ways. So we have to look at the different kinds of communications in order to work out what the terms of the contract are. What we're really going to focus our attention is on, in express terms, is the terms that are recorded in some tangible sense. So in particular, we're going to look at writing, but that are recorded in some tangible sense. We will spend a little bit of time moving forward next week as we talk about the terms that are implied by law. So, what kind of factors does a court use to determine which communications form the basis of the contract? If we have a conversation, or two parties have a conversation, and they end up with a contract, how does the court work out which bits of the conversation are the contract and which bits aren't? And does it really matter? So that's the kind of inquiry that we're going to be making over the course of the rest of the day. Questions, concerns, thoughts, frustrations?